I apologize. That happened so quickly, and you laid it out so quickly. I don't think anyone in the body understands what it does or what it means, so I'm asking you to explain it to us.
So first reading of the amendment, it appears to also apply not only to admission to the bar, but the continued practice of the bar. But we wanted to make sure that that was explicit in the amendment. And so my amendment to the amendment ensures that it's clear.
But I want to talk about what that means in practice. So admission to the bar means whether or not you can become a lawyer or not, correct?
That's my understanding.
Okay, well, and so continued practice means what?
Continued practice.
But how does that relate to the amendment that you're amending?
That we want the religious liberty protections in the amendment to not only apply to admission, but also as you practice law.
So let me make sure I understand. Are you saying then that aside from the admission to the bar, but in the continued practice of law, someone could raise a religious objection to the work they're trying to do or the client that they take?
Now, this is a restriction on the state bar to essentially not put a rule in place that would discriminate against an attorney who is practicing law according to his or her sincerely held beliefs.
But what would that, give me an example of what that would look like in practice. You're speaking in platitudes. I'm asking what real life, real world event are you trying to prevent?
So you can go back to Representative Leach's layout.
Well, I'm talking to you. It's your amendment.
I'm answering your question when he talked about the American Bar Association rule that they promulgated, 8.4G, that our own Attorney General said was a discriminatory, was a unconstitutional rule, that it was essentially a speech rule. And so we don't want them to be able to do that to encumber or burden the practice of law.
But that was for the admission, is that right?
No, the ABA dealt with conduct to practicing attorneys.
So can you give me an example, or can someone give me an example of a fact pattern where this would be invoked? Give me an example. Because what you're doing essentially is reading it back and forth to me.
Yeah, so every attorney has a fiduciary duty to zealously advocate the positions for their client.
Yes.
And so anytime there's something about a client's case or facts that they have a that their conscience is not going to allow them to do that, they would not be able to fulfill their fiduciary duty to that client. You know, you have civil attorneys who refuse to do criminal law. You know, you have a civil attorney who says, I could not defend a child rapist due to my sincerely held religious beliefs. And so we don't want a mismatch between the attorney and the client. And so you want that attorney to be able to fulfill their duty to the client.
You're saying that they can do that now. They can, right now, any attorney can say, I refuse to do criminal law, or I refuse to defend child rapists. They can do that now, right?
Yes, they can.
And so we need the amendment because
we want to ensure that freedom stays in place.
Here's a question. In your understanding as the author of this amendment to the amendment, is it your goal not just to give attorneys the ability to discern which cases they take, but also to discern which clients they take?
You can't have a case without a client, so that doesn't really make sense.
Well, in other words, I understand that you can categorically say, I don't take these kinds of cases, and base it on your religious beliefs.
Yeah.
But is the purpose of the amendment, or is one of the effects of the amendment, give the attorney the right to say, I don't take this kind of client, this class of client, because of my religious beliefs? And I'm talking specifically...
They already have the ability to say, all criminal defendants, I don't take those cases. That's a class of client.
Okay, well, what about race?
That's not the intent of this.
But would it work that way?
That's against federal statute.
What about religion?
That's also against federal statute.
What about sexual orientation?
That is in the state bar rules now, I believe.
Well, we're amending the state bar rules right now, so answer the question, please.
The point is that in the conduct, when you practice, you want to make sure that the attorney and the client are matched. And you don't ever want to have an attorney not able to zealously advocate their client's position.
And what about
you can do? I'm not up here to answer all these hypotheticals. You could do that all day long.
Well, you are the author. And so part of this process is that you offer yourself up to answer questions by people who are reading it for the first time.
Yep.
And so as a professional courtesy, I'm trying to understand the way it works. If you want someone to come up here or go back there and tell you that they know how it works, that's fine. But what about court-appointed attorneys? Are you saying that there could be a court-appointed attorney situation and the attorney, if this passes, says this person is a lesbian, so I don't represent lesbians, I'm not going to take this case?
I can't imagine that being a scenario, but if
the amendment passes, does that legalize that situation?
That's not the goal here.
That's not my question.
That's not the goal here.
That's not my.
This is about sincerely held religious beliefs and someone being able to say, "I can't handle your case because of it's the same reason why."
Let's put aside the goal and talk about the effect. If this amendment passes, does that legalize that situation or not?
What it legalizes is lawyers being able to practice according to their sincerely held religious beliefs as they have since the foundation of our country.
Mr. Schaefer, and this is my last comment, I understand what you're trying to do, but I would at the very least expect an honest back and forth. I think if we ask honest questions, we deserve honest answers, not a series of platitudes to avoid saying outright what we know is happening. Thank you.